Sahil, let's start.
For sure.
Sahil, you are muted.
Sorry. Good evening, everyone. Amity Innovation Incubator welcomes you all in today's insightful webinar and an opportunity to interact with our esteemed panel. I would like to extend a very warm welcome to Mr. Gerald Manohar, Mr. Abhishek Tripathi, Manuel Jose, Radhika Gupta, Janya Tony, Mr. Vijayveer Singh from our team, Mr. Yamini Bhushan Pandey, and Mr. Ojasvi Babbar. Before moving further, let me give you a quick brief about Amity Innovation Incubator. Amity Innovation Incubator, popularly known as AII, has been operating and supporting startups in various sectors for over more than a decade and continue hand-holding startups at different levels right away from pre-incubation, commercialization to acceleration and further investment support through our investment vehicle. Now, I would like to introduce our moderator for today, Mr. Abhishek Tripathi, Senior Associate and Research Analyst into Legal World. Abhishek Tripathi is a graduate from Amity University, Lucknow campus. He completed his BA LLB in 2018. He has participated and won several competitions during his college life. He's also an advocate for social equality and collective development. He's associated with several institutes which promote the cause. He's working as a senior associate and research analyst at since 2018 and is also part of its core planning team. And he's also into over to you, Abhishek.
Good evening, everyone. First, I would like to welcome you all to this wonderful session on legal due diligence startup and how to prepare for it. This is Abhishek from Into Legal World. Sahil have already introduced me. I'm an associate and a research analyst at Into Legal World. Into Legal World is a registered company dealing in publication, legal services, and education. Established in 2018, Into Legal World is now among top law startups in the country, having its office in Lucknow. Under its educational wing, Into Legal World Institute offers several online certification courses. Through our online educational platform, we focuses on skill development along with the traditional teaching. Our publication wing Into Legal World Publication have many bestseller books on Amazon. Our lecture series and 100 landmark judgment series are marked as a huge education. Now coming back to the current webinar, which is on legal due diligence for startups and how to prepare for it. In this webinar, we will be discussing what exactly does due diligence mean, who conducts it, and what specific aspects of a business are examined during the process. For that, I would like to welcome our guest, Mr. Gerald Manoharan. Mr. Gerald have completed his law degree from Bangalore and is partner at JSA Advocates and Solicitors. Mr. Gerald's practice primarily focuses on corporate commercial transactions, mergers, acquisitions, real estate, and dispute resolution. Apart from the Bar Council of Karnataka, Mr. Gerald also have membership of Singapore International Arbitration Center and Singapore Corporate Councils Association. Mr. Gerard also lead the startup initiative of the created an ecosystem to enable and grow startups by providing them access to quality legal advisory and mentoring. He works with several incubators across country including iCreate, CIIE, JITO, NASCAM to develop this ecosystem. Now, I would like to hand over this session to Mr. Gerald Manoharan to enlighten our audience about the subject. We'll be taking up the questions from the audience at the end of the session. So stay connected and drop all the questions in the chat box. Over to you, sir.
So, Abhishek, thank you for the introduction, and I am really happy to be here. The event for all of us, Professor Yamini and all the other members of Amity. Thank you for this opportunity, and I hope we will try and do as much justice as possible in the 30 minutes that I have to quickly run through the how does a startup prepare for legal due diligence. I have put together a few slides. Thanks, Saujanya, for helping me with this. And I will go through some of these slides, and I will also share some of our experiences so that as startups, you understand what the legal and the financing side is looking at. So what happens very often is that when entrepreneurs come together and they want to start a business, the core understanding of their business may be very strong in their minds, but the business operates within a certain economic and a legal ecosystem. Therefore, what tends to happen is that while attention should be given to business, a certain number of care also has to be given to some of these aspects because they really ultimately drive the organizational structure, they drive organizational procedure and discipline, and that in turn creates a good corporate organization. So when somebody is looking at collaborating with the particular startup or is looking at investing in a startup, what they do is this whole ecosystem, positive, well-structured, compliant startup will invigorate them to, invest in the company. They will be well informed, and that really helps the process. With this, I would like to go to the first part of my presentation. And so this is what I broadly intend sharing in my presentation is the contents of it is will cover a few important aspects on corporate secretarial compliance, the structural aspects of a startup, and how that is important when somebody wants to review your books. So when one speaks about a corporate diligence, unlike in the case of an individual, where the reputation of an individual precedes, every discussion, every conversation, in the company, what happens is that information relating to the company is embedded in its books of accounts, in its registers it maintains, in the database it has, in the financial proprietary. So therefore, what tends to happen is the very first gatekeeper sanctifies or establishes that a company has got a certain personality to it, right, or a certain reputation to it, is obviously its corporate, documentation which it maintains. And I will get into some of those details. So when we talk of why is a due diligence conducted, right? So we all, before we enter into something in any form of either a relationship, or you're entering into a business, or you're entering into a college, whatever may be a new adventure that you want to get into, you obviously want to understand the perils of your adventure. You want to understand where it is headed, what is going to be the outcome of it. Is it going to be a positive outcome? Okay. Nobody enters into marriage hoping that they're going to be divorced the next day, right? So a certain amount of precaution is always taken. And when it comes to a company, people who want to collaborate, it could be your investors, it could be people who want to work with you, it could be your employees, okay, who want to work with you. They do a bit of diligence on your company. And this diligence primarily is split into different baskets, right? So if I want to invest in your company, I basically break down your corporate identity into a few baskets. first basket will obviously be the business itself. Is this a good business? Is this a viable business? So, the opportunity that the business has for the future. So all the business related aspects, the business aspects which are linked to financial growth, which are linked to productivity, all fall into one basket. So that is something which I will be reviewing very, very closely. The second basket which I will be looking at obviously is the compliance basket, to see is the company compliant, right? Today I invest into the business and I realize that the business has been doing all kinds of illegal activities, non-compliant with law. Its practices are not in compliance with local statutes. So that is the second bucket. I want to make sure that the company I am engaging with is also taking necessary precautions to make sure that the business it conducts is in compliance with law within the work. And therefore, that is going to be my second bucket. The first bucket will be business, second bucket will be legal. The third bucket, process and finances, right? What is the financial propriety of the business? How is the finance being done? Are they paying their taxes on time? Are they making sure that they're receiving their payments on time? Are they making payments on time? Are they deducting taxes at the right level? Are they paying their employees on time? So these are all the financial aspects of the company in terms of your books of accounts, the financial status of the company. Are you maintaining your books of accounts correctly, okay, in a transparent manner? Okay, so that becomes a third bucket. Okay, and the fourth bucket could be your operations, right? Operations play an important role. It could be part of the first bucket, it could be the subset of the first bucket, but it is important. Operationally, how is this business being conducted? So very often what we have seen is that earlier days, people would do a financial due diligence, and they would also do a legal due diligence, because these two were important and the liabilities emerged immediately. But nowadays, what we are seeing is people are bringing in operational experts to look at the operational processes which the company has adopted while it is doing business. Through the operational process, they are able to understand multifold what is the business prospect, what is the growth of the business. The fifth bucket, which is also very important, is the people's bucket, right? There are people who are now doing extensive diligences on the human resources of the companies today. In a lot of IT enabled companies where information technology plays an important role, whether in terms of product development, software development, or services, the people play an important role. So people analysis is also being done as a fifth basket. So what I'm trying to say here is, when you are ready to collaborate, or when somebody is looking at you as a potential collaborator, these are the things that is running in their mind, and they are dividing this all into different buckets. They are getting different people to come and analyze and look at these different buckets to see how good they are, how bad they are. And then these advisors come together at some point of time and they exchange notes. So when they exchange notes, they obviously have a risk matrix, right? So are you at the lower end of the spectrum? Are you at the higher end of the spectrum? Is this depending on the risk, depending on the future, depending on timelines, then a collective decision is made to collaborate or to investment in the business. So this is how typically a diligence structure works, right? So now with respect to a legal diligence, right? So I'm a lawyer and I'm not competent to speak of a financial diligence or an operational diligence, I've just given you a broad overall view about it. But when speaking in terms of a legal diligence, okay, what is the most important part of a legal diligence, right? Uh, the idea of why people conduct a legal diligence is to clearly establish that the company has minimum red flags as possible when it comes to legal compliance. And why is legal compliance important? Because we are working within a legal environment. Every action of ours, either in the corporate world or in the non-corporate world, we are governed by laws. Everything that we do has a law attached to it. Whether we drive on the road, whether we are sitting in our offices, whether we are paying salaries to our employees, every act has an attributable law that is accompanying it. And therefore, what happens is the sustainability of the business is also very important, because it is not run in a legally compliant manner. The company will open its doors to being subject to a lot of scrutiny, a lot of harassment, and maybe ultimately, it can even get shut down because it just kind of, rolls down. The progress of the company just completely gets demolished. Okay. So this is important, right? And why is the legal diligence, right? So why is it important that you are diligent on the legal aspect of your business right from day one? Because sometimes, delay will only have a snowball effect, because the problem will only get bigger and bigger, and you may not be in a position to sometimes control the problem. You cannot hide the problem for too long, or you cannot sleep over the problem for too long. So if the company is diligent with its legal aspects, then investments come in faster. So the guy who's investing or who wants to invest, he comes, he looks at your company, he looks at your records, and he or she is comfortable, at the very threshold that this company do the right things. They will ensure that they will do the right things, and therefore it speeds up the investment. One big speed block, a speed breaker to investment is removed. Okay. Uh, Sometimes what happens is, investors really like your business model, they like your product, but and they may have a high investment threshold in their mind. They say, you know what, we're going to put an X million dollars into this company. But when they come back and look at your legal compliance, they get worried. They say, oh, you know what, I think the risks involved with this company are going to be a lot more. And therefore, what they will do is, they may try to bring down their investments substantially, or in proportion to the kind of risk that they are seeking. Okay. So how do you try and work around this, right? So from the day a baby is born, right, you cannot ever take a position and say, I'll take care of the baby after 3 years. It does not work, because it'll be too late by then. Similarly, in the case of a company also, right from the day you set up, whether it's a company, a partnership, or an LLP, you have to make sure that some of these legal requirements are properly, handled. You feed the baby properly, take care of it, give it all its right, inoculations and all the vaccinations, so that it continues to remain healthy. So the process starts from day one, and that is what happens in a company. Uh, the point is, sometimes just before they know that there is till then they let the baby cry and howl and do whatever they want to. But there will be a time when they suddenly realize that there is a prospective collaborator is looking at investment, and and then they decide, they wake up and decide that they want to start investments into the company, and they are looking at a probable investor, and therefore what they start doing is trying to clean up at that point of time. Okay, trying to clean up at that point of time. So this causes some issues, right? And that's what I want to highlight in my second screen. So what can you do to prepare? Okay, see, from a legal point of view, right, from a company structure point of view, okay, what is really important is that your books of record, your register, will have to be maintained up to date. Okay, so that is the first thing which any investigator, diligence guy is going to come and look at. So when you receive a questionnaire from a law firm or a lawyer and says that we need the following information, going to start with your article of association, your constitutional documents, then your register of members, your shareholders register, register of members, and all the associated registers, which your annual returns which you have filed year on year. The primary things you are going to be asked to produce before them, so that really sets out the history of the company. So when they start reading from one page to another, they get a clear understanding of how compliant the company has been. Okay, so it is very important that you maintain these records in a proper manner. So very often what I have seen happening is that promoters end up giving this responsibility to external advisors, and there is always a gap. So the external advisors may not be, they probably send a email is not tendered to immediately, and that causes its own delays and issues. And what I have seen very often is that a lot of these compliances are time bound. Every filing has to be done on a bound manner. And if the filing is not done on a time bound manner, one has to go and seek extensions. And this extension goes at different levels of the governmental authority. If the extension is for a period of less than 30 days, then you go to a lower level officer, maybe when the work gets done faster. But the more you let it allow rest, you may have to go to a higher level officer, and the higher the jurisdiction of procedure, the longer the time and more the expense. And therefore, what happens is the enhanced delinquency in doing it, because you already have non-compliance, you haven't filed it on time, and therefore you let things to precipitate. And I know some promoters who even say, all these things are not of importance to us. We are entrepreneurs. We understand our business. We will focus on our business. Everything else, has not been of great importance to us. This is the story which I have heard from every promoter. It is like looking at their company, looking postmortem. And honestly, every postmortem is a stinky affair, right? And nobody will admit it, but that is the fact. So, what is very important is keep your house clean from day one. Make sure that some time is dedicated. Okay, be quick to change your advisor. Your advisors will have to be proactive, right? If your advisor sends you an email, he has to send you a follow-up email so that he ignites your attention, because you guys are running the business. You may have many other priorities. Advisor, please feel free to change your advisor as quickly as possible if you feel that he is not being quick enough to respond or quick enough to take on responsibilities and close them. Because in India, what we see is people get married to a service, especially in the entrepreneur's life. They say, "Yeah, now I have to go and look for another company secretary. I'll have to look for another auditor. Chalo, we have got used to this guy. He was there from day one, so we will live with him." But you are living with somebody who is not efficient, and as a result of which you are suffering the consequences as a company. So please feel free to dump the existing advisor. It can be your lawyer, it can be your advisor, it can be your chartered accountant, it can be your company secretary, whosoever. Dump them and look for somebody who is a little better. Maybe you have to pay a little more than required, but it will solve a lot of your problems. Okay. Simple things have to be kept in mind. Holding your board meetings. As a startup, you have a larger exemption because you don't need to have 4 board meetings in a year. There is an exemption which is provided under the provisions of the law. Make sure that minutes are maintained on time. Okay. See, today you have enough of, like, as part of the minutes, you may not have your company secretary sitting in the minutes meetings with you, but today you have enough of technology where you can just dictate the 5 points which were discussed in a meeting and you can send it to him. He will put it in the minutes format and send it to you for approval. Appointment of directors, once bought on, the necessary filings to be done immediately, making sure that the directors have got their respective DIN numbers and all of that, and that is kept current and validated at all times, so that you don't have to thereafter do some cleanup with respect to some of these matters. Corporate compliance is a very, very important aspect of diligence. It is pretty much the door, it is the first door which opens out to the practice, process, and history of the company. So make sure that that is properly maintained and properly kept, so that you can very happily, in my experience of 20 years or 22 years, honestly, I have not most happily welcomed us to do a diligence on them. They say, "Oh, please come. We are 100% ready. You can come anytime and come and have a look at our documents." We have not seen any company in that prepared state. There are some companies who are, and it's always been a pleasure to have diligence some of those companies, but invariably, it is not the case. Okay, so this is from our experience, and I'm sharing it with you. The other important aspect is, some of you all have inter-se relationships, because I think a lot of startups these days are being set up with friends who have common interests. They come together. They want to set up the company because they have a great innovative idea. And as a result of which, the next level is obviously they want to set up a company. So what we've seen also is that during the initial stages, there is tremendous amount of trust. There is, bonhomie, and the relationship is so beautiful. It's like a young couple coming together. And as a result of which, what they do is they don't want to get into some of these sensitive discussions as to what is my right and versus yours, what is my obligation, what is your obligation to the company, what if something were to go wrong. Nobody wants to discuss that, right? And they say, no, we incorporated the company. The company has the standard articles of association, and based on that, we will. And they both hold some number of shares in the company. The company is set up, and they start functioning. But then the problem arises is that over a period of time, as the company is growing, as expectations are changing, as the financials are changing, financial goals are changing. Because today, when I'm a bachelor, my financial goals are very different from when I have a family. So, perspectives change, and this often result in a lot of bad blood between promoters. So therefore, one very, very important thing is, while you're setting up the business, it is also important that you clearly set out your inter-se rights as between each other and also vis-a-vis the company, so that when an investor is coming in to invest into the business, he's fully aware that he is dealing with really matured promoters of the business. The promoters have really listed out their rights and obligations. What will happen if a situation were to stand or go wrong? And therefore, you have some of these, your shareholders agreement, the terms of your shareholders agreement being reflected in your articles. Now that has to be done, and that has to be maintained, so that when somebody comes and reviews that, they have a clear understanding of how the leadership of the company is structured. Okay, so there may be so not all companies are set up with a 50-50 equal partnership. Be one partner who has a higher stake in the company as versus the other co-promoter. How do you balance these expectations? So it is important that you have at least a simple co-founder agreement, which is then reflected in the form of a shareholders agreement or in the articles, which stipulates what can happen if things were to go wrong, so that you have smooth exits. Another important aspect of this is to have some of these contracts in place, is that you are setting expectations, and these expectations modulate individual behavior from day one. If you don't have these structures in place, what tends to happen is people say, "Ha, kuch bhi, it is not written down anywhere. I can do whatever I feel like doing," right? And therefore, it becomes a problem. So there was a recent incident that we are handling, which is now a full-blown dispute. All the three promoters had the rights to sign checks for the company. It was not defined as to who will collaboration with whom. It's a very simple, logical thing to do, but there was so much trust at one time, the parties decided not to do it. And there was a particular time where one of the directors just withdrew 50 lakhs from the company's account because he wanted to do a back-end adjustment with one of his investment. He moved out 50 lakhs from the account of the company into his personal account, hoping that within the next 3 or 4 days he can replace it, and that never happened. And that was the end of the relationship between those three people. So things like this can happen, so you need to be careful. Okay, so in terms of your shareholder arrangements, what it may be, it can be your ESOP, it can be your sweat equity, your shares, and the kind of rights that you have associated with those shares. It is always good to have clear documents for all of them, because that is the level of preparedness. So every time you issue and allot shares to anybody in the company, you make sure that you follow the process under the Companies Act of either a rights issue or a private placement, as the case may be. Make sure that all the forms are filed on time. Okay, and you keep proper records of it, right? Every filing fee has to be recorded, every filing document has to be recorded, so that it is all available for your diligence people to come and have a look at it. Okay, So the objective of this is obviously, to keep a clean house. The documents speak for themselves beyond conduct. You don't need to sit and explain yourself to the investors. The other important aspect which we have seen is, young companies would like to offer ESOPs to their own employees, and therefore very often what we have seen in this situation is that ESOP plans are not properly drawn up, letters are not issued correctly, so there is, a fair amount of problem that happens. So therefore what needs to be borne in mind is, when you decide to start issuing ESOPs or sweat equity shares to yourselves or to other shareholders in the company, make sure that you have proper documentation. And you don't need to have very complicated documentation, right? As long as you have simple documentation which sets out the principles of whatever is sought to be achieved from a transactional point of view, and if that is retained with adequate, filings or whatever needs to be done at the back end, that should be sufficient. Nobody is expecting a startup to engage a multi-million dollar law firm or a large chartered accountant company to set its house together. Simple things with diligent people working on it is sufficient. The other important aspect is, now we move. So now I've discussed the basic documentation with respect to shareholding, which is your shareholding relationships, ESOPs, sweat equity, anything where shareholder are involved. The next important aspect which you will have to make sure you have is, like today, obviously the government under its startup program and make in India program has come up with a lot of relaxation for startups. It will be a good idea for you to make sure you have these registrations, right? Because one is, you can register in the Startup India portal, get the registration, and as a consequence of that registration, you can also get a few additional benefits, right? Either under the IP Act or under the Income Tax Act, where you get a 3-year holiday, tax holiday, subject to you getting that tax holiday from the tax department. So you will have to see, first is register yourself as a startup, apply for those exemptions and relaxations which will help you in minimizing your expenditure, which will help you in putting you onto certain platforms which will give you better visibility, which will make you more visible in the eyes of investors, right? So don't do multiple things, because I have come across startups who have their finger in multiple platforms and they want to do all kinds of things. So I think there becomes a dilution of time. So I that you do that, but to the extent required, to the extent it is practical, please make sure that you have some of these licenses and registrations in place, so that it will always be of advantage. And some of these certifications will also make the company's profile look good. Okay. I'm not asking you to get an ISO kind of a certificate for process, but simple things like the right registrations are very, very important. Okay. Abhishek, how much more time do I have?
I think we can stretch it to 10 to 12 minutes more.
Okay, thank you. So now, once we've looked at registration of the business itself, under any scheme that's available with the government. So the next bucket, from a diligence point of discuss is that every operating business in the country will have to comply with laws, right? So obviously the first is the structural law, which is the Companies Act. But depending on its area of operations, you have to make sure that your business operations are compliant. Okay. So for example, if you are a product company, and if you're, let us assume that you are manufacturing an electronic product, while the prototype of the product is ready, the first thing you will have to see is what are the basic required for you to keep this product marketable. Is it the EEI certification? Is it the ISI certification? Or is there any other governmental body which will review and approve this product? Is there any special approval you can get for the product from an IASC or something like that, right? Or any other industry body which can approve your product, which will add credibility to your product? You will have to make sure that is obtained. Without that, I don't think you can try and go into the market and try and sell the product. If you're selling a food product, for example, registration under the FSSAI Act is absolutely important. If you're looking at a medical modeling, or if you're looking at a pharmaceutical product, then obviously the drug controller comes into play. So the most important thing is product recognition, and the right approvals for the product itself is very important. If you're developing a software, right, you will have to make sure that the software is compliant with the applicable laws. And I'll come to you, I'll discuss that a little later. Okay. Now, along with so primarily the registrations required with the product. So that is something that is the first question that's going to be asked. So if you're operating a business, if you have a manufacturing unit, for example, or you have to set up a manufacturing unit, that manufacturing unit will have certain absolutely necessary licenses without which you can't start your manufacturing process. Or if you are outsourcing your manufacturing to somebody else, then that will have to be taken into account. Suppose you start selling your product directly into the market, you will have to comply with the legal metrology norms in terms of your labeling and have to have in place. Very often people start marketing the product and their products get seized and they have no idea what's happening, right? So you'll have to make sure that some of those product related compliances and approvals are taken into account. Okay. The next bucket is business operational, related approvals, filings and licenses. Like I told you, that every business will have a certain bunch of approvals and licenses which you will have to procure, or even registration. If you have employees working with you, then obviously a whole bunch of labor laws, come into play. Okay, starting with the minimum wages till the payment of gratuity, there are different legislations which will be applicable to your business depending on the number of employees you have, right? So sometimes some legislations, the threshold is 10 employees. In some legislation, the threshold is 20 employees. But you will have to start that compliance as soon as you start operation. For example, the shops and commercial establishments registration is a mandatory requirement right from day one. If you're doing if you're under the municipal corporation legislation, you will most definitely need a trade license, without which your business can't survive. So some of these are very, very elementary. And with respect to your labor licenses, any company will have about 7 or 8 compliances to do. And some of these returns under these legislations will have to be done on a quarterly basis. Sometimes, whenever there is a transaction that takes place, you will have to make the necessary filings under the respective laws. So therefore, you may not have, if you have a good HR team internally who is also able to track all of these compliance, it is fantastic. Or the other option that you have is to outsource this particular compliance work to a HR consultancy, and they will be able to do it for you on a regular basis, so that you do not have gaps in your filings, because annual filings may be there. Annual filings are there across all the legislations. You will have to maintain your muster roll, make sure that the list of employees are maintained, so that when a person is diligencing your HR detailing, he will be comfortable that all the HR related compliances are in place. See, there is always an element of oversight that can happen with respect to any compliances. That analysis of risk will take place at the time when the parties decide to proceed with the transaction. But the problem arises is right from the word go, they only see multiple red flags during the course of their diligence. Then that becomes very difficult for them, because a lot of individual investors who are willing to take a broad spectrum of risk. A lot of investors today are institutional investors, and they are also accountable to their back-end investment team and their investment committees to make sure that they are investing in well-structured, well-established, compliant and responsible institutions. And therefore, you have to make sure that these things are properly maintained. Okay. We have completed our discussion with respect to approvals and licenses which are essential to your business operations, and also with respect to other approvals and licenses as you may be required in the course of your daily business transactions. Now comes an important aspect on keeping the house correct in terms of your own contracts, right? Now, what tends to happen is sometimes some startups, what we have seen, or not only startups, even large companies, they say, so long as we are comfortable with the government and we make sure that the government officers are not coming and pounding on our doors and trying to initiate action, to the extent we are compliant with those aspects, our internal aspects, we will be a little more chilled out about it, right? So we will take, we won't be we will not give it too much attention. We won't give it too much time. But I don't think that works, right? So because we have seen a lot of companies where they do transactions but without contracts, okay? They probably, because the need of the business is so intense and so important, that parties just execute, send email conversations between each other, and they proceed to go ahead and execute a contract. Employees are brought on board, but employee contracts are not executed. Even if employee contracts are executed, it may be a one-pager or a two-pager or offer of employment kind of a document. Policy information is not provided in any of. So I'll give you some examples, okay, of where things have gone wrong from experience, okay. Now, the first thing that happens is with employees, it's very important that you have good contracts executed with them, and a lot of templates are already available in the website. In our own website in JSA, we offer it as a free template. You need to make sure that a good employment contract is executed between you and your employees. It is because what happens is, in the event of a dispute, that document is you can go back and rely upon. And matters relating to copyright and matters relating to assignment of IP will have to be very strongly tracked, because we have seen this even happen with co-promoters. So there was one interesting case where two promoters came together to set up the business. Both of them were coding experts. They came up with a fantastic application. And then what happened was, between the two promoters, there were a lot of differences of opinion. And one guy left the business, okay? But he went and started a competing business, business, because obviously what had happened was he had not assigned the copyright to the company. The copyright, whatever work he had done insofar as his own expertise, continued to remain with him. And therefore, what happens is, if we have to initiate action against such a promoter, if the company then came to us and told us, hey, that co-promoter took away a lot of our IP, So my first question was, did he sign an IP assignment contract with you? And the company said, no, we don't have any such thing. In the absence of an assignment agreement, where he has undertaken to transfer and assign all of his IP, which he develops in the course of his employment, becomes a very sticky issue to establish the same before a court. Underlying documents are not there, right? Of course, there is a principle in law which says that any work that was executed by an employee during the course of his employment shall be deemed to belong to the company unless it is otherwise contrarily mentioned. So the moment there is language to that extent, which clearly establishes that you should have a contract, and the contract should specifically assign the IP to the company. So this is very important. I've also seen situations where web domain names, Twitter handle names, Facebook accounts have been registered in the individual's names and not in the name of the company. And very often when promoters come together, one promoter will go to Big Daddy and register the domain name. One fellow will go to Twitter and get an official handle for the company in his name. And if things go wrong, you have multiple components of the business with each guy holding it. Then what happens? It is very important that all of this moves into the company. A little bit of effort and time it takes, but don't let it hang on till the last minute, because the more you delay, the more severity of the problem is going to be. And then the next important aspect is on contracts. You have a contract methodology. If you are entering into a contract with a third party, if you're providing services to a third party, or if you're receiving services from a third party, it is very important that you read those contracts, or you make sure that you provide a contract. In that contract has to specifically have a few important aspects: commercial aspect in terms of amount payable, time within which money has to be paid, what is the maximum damages that can be claimed by the other side, is there a cap on the liability of damages, what is the status of intellectual property in those matters. So these are some things which have to be captured in a contract. It can be a simple contract, but a contract speaks many times louder than words, than mere words in the court, in the case of a proceedings. What happens is there is no contract, then people are hunting for emails. They are going back and looking at old emails of 3 years and 4 years to see if they're what the real intent was. So that intent has to be captured in the contract. Have simple contracts which are very clear from a business point of view. You don't need to have a 100-page contract for a simple services document. Have simple contracts. Make sure the commercials are properly written in it, and you retain it. Pay the appropriate stamp duty as may be applicable on those contracts, and keep it safe with you, so that tomorrow, it can be a good document for review or use in the future. Other part which I touched upon, right, is intellectual property. IP agreements, are very, very important. Today, a lot of our business are knowledge based, and you do not want to dilute the knowledge and the IP that is created in your business in any form. So make sure that you have contracts with your employees, contract with your service providers, contract with your consultants. Anybody who is going to be contributing to this IP, please make sure they sign this IP. Please make sure that you have non-disclosure agreements with anybody. An NDA is a 2-pager, and if it is a simple NDA, nobody will hesitate in signing it. But an NDA has very, very strong legal implications, and also it is a very, very good supporting document to establish the intent between the parties at the time of signing the non-disclosure, because they are undertaking that some information which is going to be shared with them as consultants, as employees, or as service providers is a confidential information. So any breach of that, you will have a right to take a right to initiate proceedings against them. And why is all this important, right? That is because a third party is now reviewing your house. When an investor comes in and he looks at your house and he sees that your house is kept well, it gives him a sense of comfort to come and settle in with you. He will feel happy that he is having a meal, or with somebody who he is confident of, who he knows, whose kitchen operates well. He knows that there are no cockroaches running in your kitchen vessels, because by the look of your house, he knows that you're keeping your house clean. So that makes a big difference, right? And these perceptions play a very, very important role. And and the only perception that speaks for itself are the documents and the nature in which you have retained these documents. So it is very important that you keep this prepared, and you are always in a state of preparedness when it comes to some of these documents. And today, there is people are increasingly worried about privacy and security, data privacy. They want to see what are the systems that you have. Do you have your own email ID? Are you using a third party? I mean, I know several young promoters who still go around with a Gmail ID. I'm not saying that Gmail is bad, but then the first time when I look at it, I mean, when I look at a business card of a promoter of a company and he still has a Gmail, I'm instantly worried, because obviously, Gmail is not your private, your mail server, right? So it is a public, free to use kind of a mail service provider. So you can't have things like that, right? You will need to make sure that from day one, the concepts of data privacy, data confidentiality are maintained, and therefore, keeping that in mind, you will have the right steps which are there. Increasingly, privacy is a big issue, so you will have to make sure that sensitive information which you are receiving from either your customers or as a part of the services that you provide are retained. And especially if you are a data controller for whatever may be the purpose, or you're working on the data, or you're culling out information from the data, you'll have to make sure that you are compliant with the respective privacy policies, right? Similarly, whenever you're dealing with employees, you'll have to make sure that there is a protection of data. You'll have to make sure that the your technological backend is good. It is protective in nature. It is not open-ended. It is close-ended, and you have controls over it, right? So this usually will come up when they do your systems, right? So any guy who wants to invest will want to see how good your systems are, how good your systems are integrated, the kind of security features that you have, the firewalls that you have. So these are important aspects which come into play, and that is something which you will need to bear in mind. I think I don't have any more slide which I'm going to be dealing with. While I told you that I'm not a financial expert, but what is important is financial practices and law go hand in hand, right? So the way the kind of processes and policies that I develop within my company will not only enable the company from legal compliances point of view, but it also helps the company very strongly from in its financial protocols and the way the financial function is handled, right? So what is very important is that you set up very simple processes when it comes to financial processes, whether it is issuance of a purchase order, receipt of money, receiving the money by way of through your bank, through your proper accounting channels. Today you have multiple UPI channels which are available, and see the problem that arises. The larger the number of channels of receipt of money, the greater the potential to lose track of the inward remittances at times. So you'll need to make sure that there is a reconciliation system that is set up, at least every week, or your financial consultants will advise you better on that, so that you understand clearly your cash flow management. And what is also important is that your practices when it comes to signing of checks, issuance of checks for receipt of checks, the way you keep track of delinquent payments. Suppose your debtors don't pay you on time, what kind of action have you initiated against them? Do you send out a reminder to them? Do you follow up on your payments on time? What is the cycle of recovery? What is the cycle of payment? What is the cycle of payment of deduction of TDS? And if you are covered under the GST, then obviously your remittances under GST are also very important. Otherwise, you end up suffering to pay very high penalties. So this also needs to get integrated with your systems. So what technically happens is your legal front end, your process back end, and your financial transactions all tend to give the investor a very good feel about the company. And as I told you, in the case of a corporate, the only thing that speaks for a corporate are its documents, its registers, its books, and the database which it has. Of course, the face of the entrepreneur is important, the face of the technology is important, but if the face of the technology is very strong, but if the compliance is behind the face of the technology are weak, then the investment will obviously, with the investment offer which you will receive, will also be a fairly weak offer in those terms. So there has to be a good marriage of both these elements, and it is only that which will facilitate long-term investments, long-term investors, long-term goals, which will help the growth of the company. So I conclude my presentation with this. If you have questions, I'm open for questions. The entire panel is available, and we will answer the questions appropriately. Thank you very much.
Thank you so much for this wonderful session, sir. It was certainly very informative, and most of our questions are already being solved by you. But there are a few questions from the audience which I would like to put forward. First question is from Nikhil. Would it be possible to share a generic co-founders agreement or the points that need to be covered in the co-founder agreement? Our understanding is that the co-founder agreement is very subjective and unable to find an anchor to work upon.
So I mean, we can share, please reach out to us. We'll be happy to share a template of a co-founder agreement with you. And you can start from there. No issues.
Okay, sir.
Does that?
Hope, Nikhil, this helps you. And the next question is from me that sir, there are many points where in the initial stage of a startup, there are overlapping of duties. So in a very, this happens mostly in small teams. So what should be the point where the distinction in duties should be pointed out that these are these persons' duties, where we should avoid overlapping of duties in startups?
I think that's a question, Avish. I can see this is more an operational and a practical aspect, right? See what tends to happen in some of our early stage investment companies. Roles have been clearly defined. So, for example, one promoter takes care of the technology aspects, whereas the other one takes care of all the marketing related aspects, right? So they don't. There is absolutely no overlap at all. So anything to do with going out into the market, and that is how good partnerships also work. Okay, so you basically say that the guy who works with the technology team is also going to be largely working locally. So he will also take on the HR role. He will also be responsible for the HR function for the entire company. The guy who goes out for the marketing role may have some, because he's also going to be traveling out of the office a lot of time. He's going to be traveling a lot. So you'll need to figure out, give him a responsibility which will not be too burdensome on him to deal with that responsibility. And obviously, you will need to provide some functional parameters and also some methodologies of evaluating performance of each of these roles going forward, right? Because if you don't objectivize some of these things, then again it becomes like an unwritten rule, and he says, I don't know what the scope was. I mean, I thought I should have done it, whereas he had not done what he was expected to do. So those things can be clarified. And I agree with you, there will be a lot of overlap. There should not be, you should avoid overlap as much as possible. But again, this is an organizational aspect. It is a management aspect, but whatever decision is taken, I think it has to be documented. You have like a minutes, you put it in perspective, you put a grid chart, you say who's responsible for what. So at least people are aware what their responsibilities are.
Yeah, thank you so much for that answer, sir. That solves purpose. I request all the attendees to please drop your queries or questions in the chat box so that we may convey the same to our panelists and you have a better understanding of this particular subject. So please drop your questions in the Q&A chat box.
Sir, I have a question, and this is no, I mean, this is a question, which most startups have that, whenever we, tell them about being compliant with GDPR. So first of all, a lot of questions, a lot of startups ask us that, what is GDPR? And the second thing is that, even when we, tell them a brief about that, GDPR was implemented by European Union in Europe. So then they, next question is that how does that impact us sitting here in India when we're not even catering to European customers?
Yeah. No, anybody in the panel would like to take this question, because I am not too much of a GDPR expert. So Saujanya, Manuel, Tony, anybody who's can pick this up?
Yeah,
Yeah, I can. So essentially, as I understand, the question is on, GDPR is something that is applicable in EU, and how is that relevant from India? But I think, what we need to understand is that do the companies who you're referring to have some kind of a relationship in European Union, etc., is what matters in this instance. Now, if they do have, then yes, there will be some relevance because there are compliances relating to GDPR which may be applicable to your company in India, given the fact that you have some relationships with these companies in the EU. However, taking that into consideration, you have to also understand that India also is in the process of adopting a data privacy law, which is in the form of a bill currently, which more or less is in line with the GDPR and covers a lot of aspects as regards to GDPR, in fact, a little more as well. So I understand the concern that you are highlighting, that why GDPR, but it may be of relevance only if you have some kind of a relationship with companies there.
Okay, sir. Thank you.
Thank you, sir. We have another question from Keshav Patwari from our attendees, that how do we prevent startup failure?
Manuel, do you want to take that?
Yeah, I mean, see, if that was a question which all startups will have. So it is not a simple answer, because if there was a clear-cut answer for that, everyone would follow. So it is just it's basically how relevant is your product, how you've structured it, and all of that. So, like Jerry mentioned, one of the aspects for doing a proper diligence is to ensure there are no non-compliances. So or you'll have to I mean, like, let's take this let's split it up into maybe 2 or 3 different aspects. So the first aspect would be the startup should be an area which is relevant. So that doesn't, I mean, because you've seen, like, when the food aggregator business came in, Swiggy came. It's not an but a food delivery business. So everyone started jumping in. There were, like, I mean, you would remember how many apps were there on the same product. So the advantage is always important, but it should be a product which is relevant. So, if you can get that, great. But there's no clear-cut answer to that. You'll have to service the requirement that is there in the society. Another thing which startups can do themselves is, Jerry also mentioned in his presentation earlier, generally you will have a bunch of friends coming in together, setting up a startup. They would all have, I mean, like, in the initial stages, it's all fine. But once you move beyond the stage, there would be a difference of opinion which the founders themselves would have. So you should ensure that there is a structure. So generally, startups are not very structured in the beginning. It is just a bunch of people. It started, they've run with it. They don't have the time to stop and take a breath to get everything organized. I would still advise you should make the effort to get things organized. So, like, let's say if there are 3 people, like, the roles should be clear cut. I mean, and people should try not interfering with each other's roles. So this will help avoid conflicts. So those are, I mean, see, there are a lot of these small aspects that would come in. And then another is you will have to. I mean, some startups go expand even before there is actually a need to expand. I mean, like, they would move on to new verticals, or they would try expanding their market. They would try infusing a lot more. There should be some check to balance out requirement of funding. I mean, they should actually be a little careful when they take money from investors. See, this is actually a whole session in itself. So, but coming back to it, I mean, it's a short formula. There are a lot of aspects you'll have to consider. But yeah, even though there is a lot of madness in startups, there should be a method to it. That is what I would say. I mean, anyone else can pitch in also, please.
If I can add here, Manuel, the thing is that I think the question that was asked in the initial stage, which is on the founders agreement, plays a vital role here, I would suppose. because when a startup is formulated, I think it's with certain objectives, and those objectives have to be clear amongst the founders, and those are critical for the business functioning as well as the future of the startup. So if you have a founders agreement that is put in place which clearly sets out the responsibility, the ownership, the various aspects that the startup has as objectives, that will probably guide the startup in the right manner. As also, what is also important is that compliance should be one of the main focus of the startups as well, because typically a lot of issues come up down the line after a year or two when suddenly they see that they have not given importance to certain things, and will end up in a non-compliance, which will then result in investors not being keen about investing, etc. And that's when the diligence picks up all these issues. So I think these are some of the key factors that you need to keep in mind as far as ensuring that the startup doesn't fail.
I hope that answers your question, Mr. Keshav. We have few more questions from our audience. One is from Mr. Ravikant. How much time a legal firm takes to do the legal due diligence? Are there other categories of due diligence also which need to be considered before a startup goes for fundraise?
So, okay, I'll take this part quickly. So, Ravikant, as I mentioned to you, legal diligence is just one of the diligences which are undertaken by prospective investors, because there are other aspects, like I mentioned to you, right? The operational diligence, the financial diligence, business diligence, manpower diligence also is undertaken by investors. So really, depending on the size of your operation, you can expect to see multiple teams coming to review. But definitely financial diligence and legal diligence will take place. All the others will be dependent on the investors' risk appetite and how they want to approach the diligence. Does that answer your question?
Hope that answers the questions. We will take up the last question from today's session. Is it okay to keep the IPR of the company on founder's name, or we need to transfer it to the company? Since in certain scenario, only one founder is the innovator and want to hold back the IPR on his name.
Radhika, do you want to take this?
Jerry, I would request Tony to take this one.
Sure.
Yeah, as far as IPR goes, it's completely dependent on I think the product or the IP that is created, because probably there would be certain IPRs which the founders may like to retain with themselves, because ultimately that's what has probably started off this entire idea and the startup itself. And the intention may be to hold on to that till probably a stage where the company has set its foot and is ready for investments, at which point maybe he'll decide to transfer. But I think it all is dependent on the products and the IP that is held on. Most often, product-based startups, the IP is always held by the founders. That is what we have seen. Very rarely it's transferred to the company.
Just to add to Tony, exactly like Tony said, maybe, it'll scenario. So just consider a scenario where a founder's developed the whole IP. He starts a new startup with a couple of friends. So there is an initial period where you're not sure whether the startup is going to make it through. So you won't want to transfer the IP to the company, because then you've lost it. The founders lost it. So when you take the founder's view, it's gone into the company. Now it belongs to the company. For him to take it back, it won't be possible. Unless you write the agreement in such a way or something. but it won't. It is not an ideal solution for the founder. But when you consider the co-investors with the starter, I mean, with the founder, when the other investors who are investing, they might want to guarantee that the IP belongs to the company. And from case, but like Tony, maybe it is safe in the initial stages, at least for the founder, to keep the IP with him for some time. If the startup gains traction, then move it to the startup, because the value of the startup also would be linked to the value of the IP. Because if the founder holds on to the IP, he'll only be assigning rights to the startup to use it, but the IP would not belong only to the startup. So there might be a diminishing of value for the startup. So keeping all of these factors at the time when you are considering a fundraise, maybe at that time you'll have to decide whether you want to transfer it or not.
Thank you so much for the answer, sir. Hope that solves the question. Now, to conclude the session, I would like to call upon Mr. Sahil.
I would like to thank all the panelists who have joined us today. Our moderator Abhishek, our panelists Manuel, Radhika, Sujanya, Tony, Gerald sir. I would like to thank all the attendees on behalf of Amity Innovation Incubator and our entire family for joining us today for this session. Thank you. Stay safe.
Thank you very much.
Thank you for inviting. Thank you.
Thank you.
Thank you.
Thanks, everyone. Have a nice day.
Thank you.
So please end the session. Rahul sir, am I audible?
Yeah. Sahil? Sahil?
Yes.
Sahil?
Hello.
या साहिल आई थिंक मैं ना डिस्कनेक्ट हो गया था बोर्ड से
सर आई एम सेइंग लाइव स्ट्रीम एंड करके सेशन एंड कर दीजिए प्लीज
राइट